Good afternoon, dear colleagues. We continue our work in Ukrainian Crisis Media Center. The topic is delayed justice, why Ukraine postpones Rome Statute, and what are the threats. Among the guests, we have David Duncan, Professor, Secretary General of Parliamentarians for Global Action. Also, Mark Pritchard, MP, UK House of Commons, head of the National Group of the UK branch of Parliamentarians for Global Action. Also, Graham Jones, MP of the UK, member of Parliamentarians for Global Action. And also Oleksandra Matviychuk, head of the board of Coordinator of Civic Initiative, or Euromaidan-SOS. Good afternoon, and I'll invite Oleksandra to be the first. Good afternoon, dear colleagues. My colleagues will speak more about consequences for Ukraine of postponing the Rome Statute, that is an international court. I would like to speak about, in general, about the context of the problem, because Ukraine for 2 years is overcoming challenges, unprecedented challenges related to the fact that Russian Federation, with the help of army, occupied Crimea and started a hybrid war in Donbass. Those challenges, and they sharpened the existing problems, and such an issue as the problem of impunity, which before Maidan also that was a problem for Ukrainian society, and that is related to some reasons. One of them is Ukraine. Maybe the first time we face a great number of violation of human rights and crimes, and also they are, a lot of them, very heavy crimes. The second reason, investigation of those crimes, and that is on the shoulders of under-reformed system of law enforcement bodies and also courts and of the judiciary. If here in Kiev we complain that they are all interrelated in police or Ukrainian judges are engaged, you can just imagine the size of the problem on those occupied territories of Donbass. The third reason, dependence of investigation and on political people who are working there on national level and regional level. And the fourth point is the problem of that law is not something which we have in real life, and our legislation is not related to international humanitarian law, and also we were not able to become full-fledged member of International Criminal Court. In fact, we have this war within the law on anti-terrorist operation, and that's why we have some practical problems and as to qualifying crimes. On one hand, we have criminal persecution of volunteers who were trying at the beginning of the military conflict to provide the armed forces with everything necessary. And they transported, despite of the laws and rules, they provided equipment, vehicles, and whatever. And now they ask to defend them. And also, when we speak about the investigation of crimes in ATO area, then in Criminal Code of Ukraine, until now, we don't have such an even notion as crimes against humanity, and military crimes are written in a way that makes impossible to qualify them somehow, and that brings us to very complicated legal consequences, legal situation then justice is impossible, and that is the field for impunity. We sent requests to the national police. And, for example, in 2014, we found out that in Luhansk region, according to article torture, and they started only 3 criminal cases. So during all 2014, only 3 criminal cases, article for torturing, but the data, like illegal kidnapping or arrest. In May, there were 4 cases, and then 105, then 202, and in October, more than 500. We know that field research and also from polls among people, and also from announcements of journalists, the treatment of the people after they were kidnapped. So the problem of qualification, you have to understand, this is practically important. Also, there are 2 more important issues, and we have because what the Parliament does in legislation drafting, and I call it they use a microphone to nail. To hit the nail. Last week they passed the draft law on amnesty number 42555, and that is that amnesty law, which they discuss every year, but now they put some articles and with good ideas of MPs, and there must be. They should stop prosecution of participants of ATO for enforced steps they had to take in the reality of war, of military activities, but the problems are not result in such a fashion. Because one of the consequences, we will go into details later, of that law is that it allows to give amnesty to those law enforcement bodies that committed crimes on Maidan only because they have the status of ATO participants, and the draft law doesn't have any paragraph that the time of committing crimes should be related to ATO. So by this draft law, it seems like we have good intentions, but because of other negative consequences, we just give amnesty to those policemen who committed crimes on Maidan. The second reason, when our mobile groups are working on liberated territories, that there is not enough of motivation in law enforcement bodies to investigate crimes, because they are convinced that all those criminals sooner or later will get the amnesty according to Minsk agreements. And in fact, in this context, we cannot rely only on the International Criminal Court, because according to this policy, it focuses on top officials and on people who give orders, and the national legal system anyways will have the burden of investigation, and all of that pushes us to bring our legislation in accordance with international humanitarian law. And the Parliament Assembly of the Council of Europe paid attention to that in their resolution from April. So the Center of Civil Liberties, we prepared the draft legislation. We'll speak to the Parliament today, and a whole working group was working on that draft law, and headed by professor from Shevchenko University, Konstantin Zadoy, and some famous people like Doctor of Legal Law Sciences Havrenyuk, and we consulted with Global Action people, with Mykola Anatovsky, head of the Committee of the Council of Europe on the Prevention of Tortures, and we received comments and feedback from International Committee of Red Cross, and we do that work and present today in the Parliament that draft legislation, because we are confident that people on liberated territories, they want to re-establish not only infrastructure. We should rebuild belief in justice, and that the conflict could be resolved within the law. Thank you, Alexander.
Thank you, Alexander. The next one will be Mark Pritchard.
Well, thank you very much. I think this is my 5th visit to Ukraine. I first came here 10 years ago, and obviously a lot has changed in that period, some for good, some for not so good. It's good to be back in the Parliament of Ukraine, in the Rada. We were there yesterday for meetings, and we'll be there later on today with our co-organizing partners, the Human Rights Agenda, where we'll host a high-level roundtable on implementing the international humanitarian law and the Rome Statute of the ICC into Ukrainian legislation. Now, This isn't a British Member of Parliament, so there's two here, or an Italian Secretary General based in a organization in New York, although it's a global organization, coming here to tell Ukraine what to do. As a legislator, as a lawmaker, as a parliamentarian, as somebody who believes in the international rule of law, I'm wanting to stand with my parliamentary colleagues in the Ukrainian Rada on this issue. And across the political divide, we have about 30 members of the Rada who are currently members of Parliamentarians for Global Action. And this will rightly be seen, the issue of the Rome Statute will rightly be seen in the context of the current Russian aggression in Ukraine. However, it's important to note that it should not only be seen in that context, that in fact the work of the Rome Statute and the dialogue with the PGA began in 2003 here in Ukraine. And I think that's an important issue. So it's not about telling Ukraine what to do. It's not just to be seen in the context of the current Russian aggression. It is to be seen in the wider context of Ukraine normalizing itself internationally in the context of the international rule of law and international norms. So there's a lot of support for that. Now, obviously, there has been a different view taken by some here in Ukraine about the timing of that. Now, whether there's going to be a 3-year postponement, whether it's going to be 12 months, 1-year postponement, we will have to see. My view is that it will send the right international message to the whole of the international community for Ukraine to get on with implementing the Rome Statute at the very least. In the interim, there is no reason why some of the issues that the ICC addresses, the International Court addresses, cannot be implemented within the existing and amended criminal code, Ukraine's own criminal code. And I think that would be, again, a helpful signal. I think there's some confusion now in the international community, having worked so hard across the political divide and international observers looking at Ukraine, looking at the Rada, looking at the progress made on the Rome Statute, some confusion that all of a sudden it was halted. So I think the compromise, if you like, is to have that now within the criminal code. I think the other important context for all of this is that the ICC is not in competition. It was never designed to be in competition to domestic courts. Its role is complementarity. It's going to complement rather than compete with domestic courts. So I think that's important too. So I don't see the current setback as permanent. I think it's unfortunate, it's temporary, but I hope that dialogue will continue with the PGA, with members of Parliament. And of course, the Parliamentarians for Global Action have representatives from 131 national assemblies and parliaments. And our role as members of Parliament, as legislators, as lawmakers, is to have dialogue and share best practice with lawmakers in other countries. So it's not, it's not just people from the UK. We have people from Latin America, from Africa, from Asia, from other parts of Europe. So it's us all working together for the greater good and making sure that all of us are subject to the rule of law, and there is no impunity for those that commit serious crimes. I just want to briefly say that the commitment that I have personally to Ukraine, I come from the governing party, although I speak personally not as a member of the government, but the personal commitment that I have is that I'm here today, and in 1 hour's time, the United Kingdom will have a new Prime Minister, Theresa May, the former Interior Minister, and David Cameron, within the next 30 minutes, will resign formally as Prime Minister of the United Kingdom. So on such an important historic day, I could have gone back to London. I didn't, because I'm committed to supporting Ukraine, the people of Ukraine, not any particular political party, but all the political parties of Ukraine who want to and subscribe to and sign up to seeing the international rule of law complementing domestic law on the issue of impunity and ensuring that all of us abide by the same rules internationally. Thank you.
Дякую, пане Марк. Наступним до слова запрошується пан Грехем Джонс. Будь ласка.
Graham Jones, please.
Having us here today, and thank you to the people of Ukraine who have been wonderful to us for the few days that we've been here. It is certainly a special relationship. We've been in the RADA speaking with colleagues about issues to do with international criminal law, but also beyond that, the problems that you have with the aggression from Russia in eastern Ukraine, and to learn about that. And I won't go over the points that Mark has raised other than to reinforce a couple of them, that you have colleagues here who are committed to international law. You are in the process of ratifying the agreement to join the International Criminal Court. We are pleased about that. It makes Ukraine part of the family of nations that are concerned that it is international law that determines the future of the world, that aggression is wrong. It should be, it should not be used country against country, that it should be that law that is the backbone of our nations and of our future and of our peace. There are 30 members, I understand, now in the RADA who are committed to the PGA, and that's a welcome step forward across all parties in Ukraine. And I think that there is progress being made. Of course, the amendment is for 3 years, to postpone for 3 years signing up and ratifying. I think we would like to see if that's possible to shorten that time and for there to be international justice for some of the most serious crimes that may occur, and if they do occur, that those people are held to account. Again, to reinforce, I think it's really important that Ukraine is seen as part of that wider family across the globe, and we certainly have been impressed by some of your parliamentarians and the attitude that they have towards international law and the fact that they want to be part of that broader family. Some of the issues that Mark didn't touch on that we've also discussed are the internal issues in the Donbass area, the fact that there are so many displaced persons, around 2 million, which causes us great concern, and we will certainly go back and reflect on those. Mark's on the Council of Europe. Those issues will be raised by United Kingdom parliamentarians. I think that we have to look at this issue. We've got a migrant crisis in Europe, but we must not forget the issue within Ukraine of displaced persons, which I think is important. There is also a concern about some of the conditions within the Donbass area and Crimea, the Tartars, but in the Donbass area, the fact that we understand that the death penalty has been reintroduced or is about to be reintroduced, which gives us great concern about the path that is being taken in that particular region. So these are some of the other issues that we are discussing that we will take back to the United Kingdom. All I can say is that I think it's a pleasure to be here. I'm really pleased that Ukraine is on the right track, and hopefully we can accelerate that process as part of this delegation. And maybe, I know Mark's been here 5 or 6 times, this is my first visit, and maybe I can come back in the next couple of years and see that progress and go back to the United Kingdom and say, report back the progress that's been made in Ukraine. So thank you very much.
Дякую. До слова запрошується
I invite Mr. David Donketti.
It's a great honor for Parliamentarians of Global Action to continue the cooperation with the Center for Civil Liberties, Human Rights Agenda, represented by Oleksandra here, and all the civil society movement that was instrumental to the transformation towards the democratic situation that we have today with the Maidan protests and movements. I want to stress here also that we have worked very hard in the last 2 years to ensure that the political leadership of Ukraine was sensitized on this issue of the fight against impunity. And as reported by our 2 members, I can tell you that there is this sensitivity among all political parties. So the real challenge here is how to address the postponement clause contained in the Constitution that was attached to the judicial system reform package that was adopted by the Rada. And as far as we have understood, that doesn't mean lack of support for the ICC, but only some sort of delay. Necessarily this delay it needs to be addressed, and what we also would like to do is to engage with members of the military and other representatives of society here to explain that ratifying the Rome Statute will only give rights and not put additional duties on the side of those involved in the armed conflict, because the Ukraine already accepted fully the jurisdiction of the court on all the situations occurring in its territory, and above all in the areas of its own territory that were unlawfully attacked and partially occupied or felt outside the control of the central government. So it's not correct to say that by ratifying the ICC, you would give weapons or tools to enemies of Ukraine or to the Russian Federation or to other entities to bring in legal claims that could not be brought today. As of today, the same legal claims could be brought either before the ICC or before any other body. In addition, the amnesty that Oleksandra mentioned cannot clearly, under customary international law, extend to crimes against humanity, war crimes, and the crime of genocide, or even the crime of aggression. These are crimes under international law. They were punished in Nuremberg as of 1945 at the presence of judges from the Allied powers, which included the United States, Russia, the US, the UK, and France. And the same law would apply today. So no one can claim for immunity from these crimes or apply amnesties to those crimes. And in fact, even the Russian Federation is not claiming for that. So there is a lot of misinformation around the issues surrounding the ICC, and I think it's the duty of the media to address these misconceptions and misperceptions. That's why we are organizing a seminar here. I am available for any question, as our members are. Our delegations also consist of rule of law specialist Leila Nikiu, who is sitting there, and our program associate Frederica Shrekerikova. Okay, sorry, I cannot pronounce your surname, Frederica. And they're also available for any question. And I hope that our meeting this afternoon will conclude with a statement that can reaffirm the commitment of Ukraine to implement and ratify the Rome Statute. Thank you.
Thank you, Professor David. If I may, I just wanted to, Oleksandra, if I may, just make a couple of comments on Brexit, given that we're here. Theresa May, the new Prime Minister designate, and within an hour, the Prime Minister has stated clearly that Brexit means Brexit, and even though she campaigned to remain in the European Union, as did I, we recognise the will of the British people. What Brexit will mean, we will have to determine over the coming weeks and months, and when we trigger Article 50 is clearly a matter for the Prime Minister and the new Brexit Secretary of State who will come into the Cabinet, and again we will have to wait and see. On economic policy, whether it means we're in the single market or not, again, it's a work in progress. But I just wanted to say on foreign policy, our Defence Secretary, prior to going to the NATO Warsaw Summit, said that the UK will do more in NATO. And as far as our policy towards the European Union is concerned, we may be leaving the European Union. Our relationship with the European Union may be changing, but the European Union and Greater Europe will remain strategic partners and close allies. So there should be no noticeable change at all in foreign policy. If anything, one could argue that the United Kingdom, both for the period we remain members of the European Union and when we come out of the European Union, will remain robust in its foreign policy, particularly in this region. And as far as Theresa May is concerned, she is a proven leader, huge experience, the longest serving interior minister in British history. And she is a formidable, impressive, proven, strong leader. So the people of Ukraine should be rest assured that the United Kingdom remains and stands shoulder to shoulder with the people of Ukraine and wants to see peace restored to this region. Thank you.
Thank you, Mr. Marks. Thank you, dear colleagues. Will there be any questions or clarifications? Yeah, please. Будь ласка, представляйтеся і адресуйте своє питання.
Вітаю вас, шановні.
Greetings, the journalist, the correspondent of the Facts of the Week publication. Esteemed colleagues, the question is very simple. In the legislation, according to the Constitution of Ukraine, we can create our Brexit in Ukraine because people of Ukraine are the basis of the law, and directly we can create all conditions needed. Once the parliament doesn't want or cannot sign this Roman Statute, then people of Ukraine directly can sign such document, can delegate the powers via you, via members of parliament of other countries, if we trust you. Now, we are in hybrid war and we need to sign these documents. Everyone knows that. And the question is very simple. How? What do we need to do together to have this issue resolved positively and finally?
Well, I'm sure Professor David will say some. I think we continue the dialogue. We continue to have meetings with the human rights agenda and parliamentarians, global action. I would encourage as many members of parliament of the RADA to join PGA, where we can continue to share best practice. We know that every country is unique, has a unique set of circumstances, but at the presidential level, you have a new prime minister. Your parliament is different to every other parliament. So, and we respect the differences, but at the same time, we can share best practice and we can stand shoulder to shoulder with individual members of parliament, not taking political sides, but those that want to see the international rule of law established, both for its implementation for practical reasons, but also sending the right signals internationally, not just in Europe, but internationally, about the people, the government, and the Parliament of Ukraine.
And I think what we can do together, and of course the sovereignty is with the people of Ukraine. And the parliament represents the people of Ukraine, the government represents the people of Ukraine, the judiciary is accountable to the people of Ukraine. There is nobody above the people. We believe in democracy. And the representatives of the people have unanimously adopted the Ukraine-European Union Association Agreement. Nobody forced them to do so, which contains 2 articles that binds them to ratify the Rome Statute. It's there, it's already the law of Ukraine. So the people of Ukraine and your publication and other publications can make these representatives of the people accountable to what they've already decided. That's the fully functioning of democracy. That's one thing that could be done. The other thing that can be done that we have understood, contrary to the opinions of others, that some experts in constitutional law, including those within the government, they believe that after 1 year, not after 3 years, but after 1 year, the constitutional amendment postponing of 3 years could be repealed by a new text to repeal that transitional provision. So that's a role that can be played by the parliament, by the people, by the government leaders themselves in the executive, to call for the president to take this step towards removing that obstacle to immediate ratification. Of course, we are here, as Mark said, to exchange the experience of other countries, but ultimately the decision is all within Ukrainian society.
And I think sharing that experience also extends to, in other countries that I've been to, I've seen some interior ministries, some ministries of justice, individuals on national security councils in different countries share some genuine concerns about the Rome Statute. But I would say to any individuals that may have those concerns in Ukraine, go and speak to some of the European Union defense attaches, or go and speak to ambassadors and share those concerns. And those concerns may well have been concerns in those countries as well to begin with. But those concerns were answered. So it's perfectly legitimate, perfectly understandable for some people, perhaps in the Ministry of Interior or perhaps in the military here, to have concerns. I'm saying let's have a dialogue about it, or go and have a dialogue, go and ask those difficult questions and see what the answers are, and perhaps the answers are far better than perhaps they imagined, and then alleviate some of those concerns.
Thank you, Mr. Marks. Thank you, dear colleagues. Unfortunately, we don't have time for further questions, as another press conference is coming in a few minutes. Dear journalists, if you have some additional questions, they could be asked off records. Once again, thank you for coming, and looking forward to seeing you here in the nearest future. Шановні колеги, наступна подія.
Dear colleagues, next event